Hi, my name is Aslam Mullah and I am a registered attorney. That's what we're going to be covering in today's video. You're watching this video probably because you have a Ccma case coming up. Now there's 4 major stages when it comes to a Ccma case. 4. The first is preliminary issues. What does preliminary issues mean? It's a big fancy word. The long and short of those things that deal with the technical points of your case. For example, making sure that the parties are correctly cited, like the employer and employee. You served a copy. The third thing is making sure that you refer your case within 30 days. Now, the reason why it's called preliminary issues is that's the first thing that a commissioner at the Ccma is going to address before going into the facts of your case. Meaning, if you don't get the preliminary issues sorted out, you're more than likely to lose the case on a technical point. So it's very important that you check that you've complied by citing the right parties, you served a copy, and that you filed your case within 30 days from the date of dismissal. If you do it after 30 days, then you have to do something called a condonation. Basically, there's an explanation as to why you couldn't comply within the 30-day period. What does substantive fairness means? Essentially, that deals with the reasons for the dismissal. So that could be misconduct, it could be retrenchment, it could be incapacity, illness. There are numerous different reasons. Substantive fairness is basically dealing with the evidence in your particular situation. What evidence do I have that can prove my case at the Ccma? Do you have documents, witnesses, and then think on the other side as well, the other party that's going to be hearing my case. What evidence do they have? What documents do they have? That deals with substantive fairness. Procedural fairness, in essence, is did the employer follow the right procedure when they dismissed you? 5 requirements under procedural fairness. First is, when they were holding the disciplinary hearing at the workplace, did they do it in a language that you understand? The second thing is, did you have enough time to prepare for your case? So, for example, if you were given a notice to attend a disciplinary hearing in the afternoon, that's not enough time. Because you still have time, you have to go and gather your evidence. You need to see what witnesses you have. The employer must generally give you 48 hours of notice before a disciplinary hearing. The third is representation. So at a disciplinary hearing, did the employer give you an opportunity to be represented either by a trade union representative or by a fellow colleague? Number 4 is, did the employer give you an opportunity to defend yourself and give your statement of the facts or whatever happened? And the last thing is, did the employer communicate that disciplinary hearing to you in writing, the ruling from it? If you're successful in your Ccma case, what outcomes are you more likely to receive? The first is reinstatement, the second is reemployment, and the last one is compensation. The reinstatement means you get your job back exactly as it was before you were dismissed. So you were working as a financial advisor in a company, you got dismissed, you'll get your job back as a financial advisor as if you were not dismissed. The second is reemployment. So if you were working, for argument's sake, for Vesson, and he did something very bad to you, you can go back to the Ccma and say, I don't want to work for Vesson, I want to work for Joe So, whatever it is. So that's reemployment, where you go back to the company, but you maybe report to somebody else or you work in a different department. The last one is, most employees go for this one, it's compensation. That basically means where you get money. If you need help in your situation, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best, and I'll speak to you soon.